a lot of evidence to show involvement of other accused who are providing aid to the accused. Only because now the trial court is conscious that A3 got bail. Only because the agent accused is released on bail, the applicants cannot claim parity. The role of A3 is different than the role of the applicants who are prominent and key persons. CCTV of collector has been collected. It signifies presence of the applicants. CCTV of the SBI gate has been collected to show how incident took place. Disclosure has been clear. It is correct there are no criminal antecedent. Not dispute the other accused, including shooter, has strong history. There are cases of murder, robbery, dacoity registered. It shows that the applicant Hasmukh is running a crime syndicate along with others who are members of the syndicate together head the conspiracy. May be correct. Kindly mark this line. It may be correct that the applicants have joined the crime syndicate for the first time by hatching a conspiracy of the murder. They therefore became members of the syndicate and can be charged with Makoka. There's nothing wrong with this proposition of law. That's the company you keep. If this is the company you keep, you will be deemed to be members of this. Now we are at the foot of 236. The murder of Rajesh was an activity undertaken by the organized syndicate. Can be said to be a continuing criminal act of the syndicate, of which the applicants are members. Having regard to the bar under 21(4), no bail can be given.
The only difficulty is, of course, this is an order where an application for bail was considered. How many times this court also said the observations on merits
should not be any judgment.
It should not. And of course, we need not say anything on this to the city council.
So
the question is whether first thing, no, the murder of deceased in a criminal trial, of course, after considering the evidence, the court has to consider is it homicide? Yes. Only thereafter the court can come to the conclusion whether it is murder. All those things. Now here,
the fact that he was shot is undisputed.
No, not here.
No, let me answer what your lordship put to me.
And again, the conspiracy, prima facie, that is the only thing the court can.
Yes.
But here, it appears that it is considering the case after the trial. That's the way in which it was happily weighed, we are only saying. It's not the way in which an application has to be considered.
The lordships were a part of Vijay Madan Lal.
Yes.
On 45. Now, my lord, unless the court looks at under this special provisions, unless it looks at those facts and comes to a conclusion that he is not guilty, he can't be granted bail. So therefore, it is not a 439.
Yesterday or day before yesterday, some other decisions were in PMLA also 45 and 50 with respect to that.
So those are recent judgments, my lord, which I had appeared. Those are judgments which now say that the rigors of 45 will be relaxed if there is delay in trial and the length of incarceration. Those are those judgments. But not really on 20.
Anyway, the review petition is pending.
The review is also pending. Now, my lord, your lordship may note, that's a 7-year sentence. This is the sentence of life. Now, 21(4).
We only say the twin conditions to be looked into.
21(4).
Can it be said that he has committed? Or the other thing, whether he will indulge in similar. So therefore,
the earlier part that he has not committed, judge has to correct.
We only say
just read
the way in which it was done.
Let me just read. Bail will not be granted unless. I'm just reading the relevant part. The court is satisfied that there are reasonable grounds for believing that he is not guilty. To come to that conclusion that he is reasonably believed not to be guilty, it will be different from a 439 case, and some amount will have to be examined.
No doubt. That is why we say prima facie.
Right.
Otherwise, what would happen is, if this trial has to happen before the very same judge, No, the party will think that no, already arrived at a conclusion.
I know.
So we are only saying that
Agreed.
prima facie,
Agreed.
and then the trial, the purpose is whether
I bow down.
that should
But
be.
the High Court, my lord, instead of going into this, even prima facie, does it on parity. That is the error. The High Court.
We are only saying about the way in which. Now that we come to the other.
Yes, now come to the High Court, my lord. The High Court, my lord, ultimately grants on parity and not on the mandate of subclause 4, that the High Court records its own prima facie finding that he is not guilty by reversing this order. That's what the High Court has to do. There is no question of parity here. That too, my lord, between the kingpin and a mere agent. Now come to the High Court.
Yes.
In this slide, you will see
Yes.
the High Court doesn't refer to the trial court, just does it on parity. Where is the question of parity, my lord? Where it is 21-4.
Treats them as farmers.
Kindly, my lord, see. After, my lord, the
Around 9 parents.
just come straight to, my lord, page 9, para 11. In order to appreciate the rival, page 9, para 11.
Yes, yes.
In order to operate rivals, I have gone through the record. Undisputed, please mark. Undisputed, the dispute with regard to Kamble family was pending between A1 and A2 and the deceased since 2009. It appears that A1 and A2 were taking recourse to legal remedy. It is seen that the accused are from farmers. It is seen that accused constitutional position background appointed A3 for litigation. It is seen from record that A1 and A2 did not directly deal with deceased at any point of time. Absolutely wrong. They came to my office 10 times. They came to my office 10 times. They wanted all kinds of people to intercede. They brought A3. Next. The record reveals that A3, in order to sort out the dispute, arranged various meetings. Correct. It is seen in the meeting, Rahul was present when demand of 10 crores was made. A1, A2 was not present when demand was. This fact is stated, categorically stated by A3. A3 cannot be supported. A3 and A1, A2 are all together. Now, evidence would show that deceased has settled. Please mark. Evidence will show that deceased has settled the dispute. Completely wrong. There was no settlement. They said 10 crores, I said 7 crores. No settlement, cases were going on. Second error. Now, third, the chart compiled is also. Now, see 12. See 12. It is true that on account of pending disputes between A1, A2 and the deceased, there was motive. So, finding of motive in my favor, settlement not having taken place is also a fact. They were wanting my property is also a fact.
No, just one thing. Now, what is the basis of arriving at this conclusion?
Yes.
That there is no evidence even to suggest that accused numbers 1 and 2 were directly or indirectly in contact with the.
Absolutely wrong. Because it is perverse. It is on record that, Lord, any number of meetings were arranged. I had purchased the land, litigation was going on, and the start of para 12 line, Lord, indicates that it is true on account of pending dispute with A1, A2, there is motive. Then, Lord, 5 lines down in para 12. Similarly, CDR placed on record indicates that he was in touch with the main accused.
Just one.
Lord, page 10, middle. Page 10, middle. I'll show you, Lord, error after error. There is no evidence to suggest, kindly see this, to suggest that A1 and A2 were directly in contact with the gang leader, accused number 4. Now pause here for a second. Turn back a page. Turn back a page.
Yes.
To page 8 bottom.
Yes.
Para 10. Learned advocate for the informant interviews adopt. Besides, the learned advocate submitted before the occurrence of the incident of murder, 15 to 20 meetings were held. Advocate submitted that one call was made by accused A1 on 7th August to A7. This Rajesh is A7 who took A4, the member of the gang, who took A4 on his scooter and escaped. And all of them are present. All of them are present at the collector's office. What's the point of saying there is no call when you are together? The conspirators are standing together. Not at the collector. Come back to 10 minutes. It is undisputed.
There was no call to A4 on the street.
Please, if you don't mind.
A factual error, nothing else.
It doesn't matter to A4. You are standing together.
Yes, but you said it is
No, one second,
A7.
please.
We will come to you.
Please, if you don't mind.
So,
It makes
only
it
a
worse.
factual error.
Understand one thing. Here, you know that we will
I
take
take it.
decision only after hearing the other side.
I take it. Please. I
And
take it.
again, scrupulously we are following the other principle, hear the other side.
Indeed.
Yes.
So, my lord, A4 is the shooter and A7 is the man who took away A4 on his scooter.
Yes.
They're all a part of the crime syndicate. To say I didn't call A4, but I called my lord A7, doesn't carry the matter any further. Similarly, the deceased had also attended the office of the collector. That A1, A2, A3 office collector, everybody was there. It is not the case of the prosecution that before the actual incident there is any quarrel or dispute. What is the court saying? It is perverse. We have had quarrel for the last 10 years. He says on the spur of the moment there is no. It's not a case of spur of the moment. This is a case of a calculated murder. The presence of accused so and so was the purpose of the case. It is seen that in the incident of shooting, no role is played. What is the court saying? No role is played. It is seen that the witnesses whose statement recorded have not attributed a specific role. It is noted serves above surface fact which we bondment limitable salary of one.
So the last observation in that particular paragraph.
Your para 13 last line.
Paragraph 12 last.
Yeah, I will go to read that.
Paragraph 12 last. If we are going into 120A and 120B, no, this could not have been there. Because why should you say the specific overt act is not required? The question is there any agreement?
So, my lord.
Prima facie. Now, for the purpose of this, now that us read this, we do not know why the High Court, without looking into the real provisions. See, it is seen that the witnesses whose statements have been recorded by the investigating officer have not attributed any specific role or overt act.
This is wrong.
No. Whether that is required is the question.
And my lord, the judge doesn't even refer to which witness where I can go through every witness and show you that this is wrong.
No, that is not the provision.
And my lord, at the end of the day, all of them are present. Motive is clear. They wanted to grab my land. 4 to 7 is, my lord, crime syndicate. They shot this person. Why would they shoot me, my lord? I have no role to play with 4 to 7. And now, my lord, see para 13, last 5 lines. Accused 1 and 2 are claiming parity. In my opinion, the grounds of parity are available. The judgment is based on this. I submit, my lord, this is completely wrong. Firstly, there is no parity. Secondly, my lord, 21-4, the judge had to examine. The judge had to say, my lord, that the order of the trial court is wrong. The judge had to say that 1 and 2 had, if 1 and 2 had no, my lord, issue at all, the position was different. Now see, my lord, 11 bottom. I am amazed. See 11 bottom. It is seen that the role played by A3 is a direct role. How? A3 is only, my lord, an agent. You catch the kingpin or you catch the messenger. He is a messenger, my lord, or an agent or an attorney. He played a direct role. It is seen that the material combined is more or less identical. Therefore, it is the
That is why we say. No. we do not know how many judgments we have to rewrite, to say that while considering an application for grant of bail, despite the provisions under 45 or this kind of provision, twin conditions here, you can only say about the prima facie thing.
Right.
Now here, who has played the direct role? Then what else is required further? If this is allowed to stand, the difficulty will be with the trial court. When the High Court said he played a direct role, normally we will only say that will carry with much weight in the trial court mind. Why all these kinds of observations are?
If I may say so, it gets worse. Turn to page 14, para 22. Random, Milord. I don't know.
Which paragraph?
Milord, page 14, bottom.
22.
Yes. Bottom. Page 14, bottom. In my view, in the facts, the above this is not applicable. It is undisputed that A1, A2, A3 had no connection with the gang leader. Now I pause here. Milord. If it is a crime syndicate, 4 to 7 are desperate criminals. They have shot my husband. How can it be said, Lord, that A1, A2, A3 have no connection, no track with them? They were all present on the day. There is pause between them. A7 ran away with A4 after the shooting. Again, Milord, para 23, last line. And I submit, Milord, this is a perversity. Last
Only one thing. You see the case where the statements recorded under 161, the person who gave such statements, now they categorically or they did not say anything about the connection of these persons.
So they did. This is wrong.
No, we are only asking.
Yes.
Because
Yes.
we can, at this particular stage, one need only to see whether anything is there. Because even during the trial, this 161 statement is not a substantive evidence.
Right, it is only for...
We know that is only for 145.
Right.
That is only for 145.
Right.
And the court is not even supposed to look into it. This stage, looking into it only for this limited purpose, at this stage, and also while considering this application for any discharge, there, this forms evidence solely for this purpose.
Correct. I entirely agree.
Anything is there.
Entirely.
That's all. The other one, confronting that previous statement, that will come only later.
Correct.
So can anyone say that undisputed or all those things,
How can he
whether
say
it is
it is
there or not? Thereafter, leave it aside. Because
Limited that to give categorical finding.
that should be the way in which these are to be considered.
They are not letting the charge be argued.
Now, Milord, there are 23 last 4 lines.
Basic thing. Because previous statement can be looked into only for confronting it in terms of 145. Yes.
Para 23 middle. While deciding the bail application, the bird's eye view of the evidence in my view will indicate that bail cannot be denied. A1 and A2 intend to get bail on the ground of parity. Again parity. Therefore, I conclude the ground of parity. 21.4 is not parity, Lord, with great respect. 21.4 cannot be used for parity in this form. That too, Lord, against an agent and the kingpins. When the judge himself finds there is motive, they were all present at the shooting. And what is the point of the judge and then Lord is not even really concerned about? He is saying that A1, A2, A3 are undisputedly having no truck Lord with the crime syndicate. Does it mean that the crime syndicate will kill me for no reason? And my lord, again the court is misapplied Makoka. See, my lord, the top of page 15 which I was reading. Just see top of page 15. Just, my lord, see that page 15? Page 15 top, the first line. Is also wrong. A1 and A2 have no criminal antecedents. All right. No crime was registered against them under Makoka. In my view, decisions of Makoka are not applicable. This is completely wrong. If you join, my lord, a conspiracy with killers, if you join a conspiracy, even if you are a new person, you join a conspiracy with killers, and it is an organized crime, which it is, because shooters came, had shooters. Then the persons who joined by giving a contract belong to the crime syndicate, they themselves become a part of the syndicate. You become a partner in the crime. How can the court say that they will not be concerned? This is turning Makoka upside down. This would mean that no new offender can ever be charged in Makoka. It is absolutely wrong. If there is Makoka, and your lordship knows Makoka is applied after application of mind by a senior officer.
Again,
this is not an absolute finding.
Read page 23.
Yes.
Sorry, paragraph 23, second line.
Correct. It is to be noted that while
It is true that the deceased was brutally killed by accused number 4. It's a matter to be arrived at by the trial court after conclusion of the trial, after appreciating the evidence. We do not understand how the high courts can enter into such findings while considering an application for bail. That means the accused need only to that particular person. It is better just go inside the bail and close the door. I am here. Why should you conduct a trial? You have already arrived at. And when the high court, the top court of the high court, the state says so, whether any trial court will say against this. You are really peeved. Please.
Then the court says in paragraph 23 that the role of A3 is more serious. If the role is more serious, why did you?
Not serious. It is said that now that he brutally killed. Accused number 4 brutally killed.
No,
so as far as that person, trial is over.
That is A4. I am now talking about A3. Paragraph 23, last 5 lines. The judge says the role of A3 is more serious than A1 and A2. If the role of A3 was more, then A3 should never have been granted bail. I mean, the argument is going around in circles. It's in circles, and there is no consideration. Now, please note, there is no consideration of the trial court's order. There is no consideration of 21(4). Findings are replete, which are perverse, and categorical findings also, my lord, cannot be made. These are 4 or 5 errors in, my lord, not considering the impact of Makoka. The purpose of Makoka was only this, that you have criminal syndicates. You have, my lord, mercenaries who are hired to kill for price.
Organize the crime syndicates.
The law of Makoka is only this, my lord, that those shooters must have prior charge sheets against them. So, if you are a person, my lord, steeped in crime, you have dacoity, murder, etc., which is between 4 to 7, you form that crime syndicate and attract Makoka. If, my lord, innocent, I am saying innocent, if first offenders join that syndicate by giving them, my lord, money to kill, you will become partners in that crime. And therefore, my lord, 21(4) will be attractive. Here the judge has given a finding that Makoka virtually won't apply to A1 and A2. Then what will happen? The trial will be split. I mean, the whole thing, my lord, will go haywire. To say that Makoka won't apply, Makoka itself, my lord, doesn't apply. It's a completely wrong provision.
Makoka.
Just see Makoka.
And pass for.
You can pass on. Pass it.
Please pass.
It will be here.
Then you show it to me.
This is not here. Maharashtra control.
Not for.
It's not here.
Let's maybe pass it. We'll also need another
No, we
copy.
have. Yes. They give.
Your Lordship will find
No, application. 23.
It's in the definition.
Lord, kindly have a look at some definitions first.
Not only the definitions, please
Ah,
read.
not-
No, in this act, we think that, of course, subject to what
Yes.
Council wants to say. No, we will have to consider section 3 also. Please read 3.
Yes.
Read.
Of course. Of course.
3, 4.
Of course.
First of all, 3-2.
First of all, 3, yes. Before that, Lord, see the definitions.
Yes.
C, D, E, and F. 2, D, E, and F. Continuing unlawful activity means an activity prohibited by law, which is a cognizable offence punishable imprisonment to 3 years or more, undertaken either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheet has been filed within a period of 10 years. So the idea is, if you are a hardened criminal, with this requirement, it will be deemed to be continuing unlawful activity. Now see E below. Organized crime. Organized crime means any continuing unlawful activity by an individual, singly or jointly, either as a member of the organized syndicate or on behalf of the syndicate, by use of violence, threat of violence, unlawful means, with the object of gaining pecuniary benefit, undue economic benefit, etc. That is, beloved, shooting or killing for money. Now see F. Organized crime syndicate means a group of 2 or more persons acting singly or collectively as a syndicate or a gang to indulge in activity of organized crime. So, my lord, 4 to 7 fulfill, my lord, the requirements of D. They fulfill, my lord, the requirements of D. And in F, they themselves become a crime syndicate, and a person who joins this syndicate will also be equally guilty, my lord, of organized crime. So the person who engages, my lord, a hardened crime syndicate or a hardened criminal will himself fall within the net of Makoka. Now come to 3, my lord. Kindly come to 3.2. See 2, my lord. Whoever conspires or attempts to commit, advocates, abets, or knowingly facilitates the commission of an organized crime or an act preparatory to crime shall be imprisonment term not filed, but may extend to life also.
Now, why we said that this is relevant?
Yes.
If we are reading 3.2, then this particular finding at rather the observation in page 15,
Yes.
the last sentence in paragraph 22,
Yes.
it would not have been there because the specific, the earlier we said, the other, sorry, which is that particular paragraph, specific overt act is not mentioned.
Yes.
Somewhere. That is not required. That is at page, paragraph 12, paragraph 12, last, page 11.
Yes.
What is to be looked into is whether he conspires, attempts. There the question is, prima facie, what is the evidence?
Yes.
Because at the stage of, that is why we used to say that there is no scope for any conducting a trial or a mini trial. That is to happen later.
Correct.
Because thereafter, now here, if this is ordered to be sustained, this is sustained. even the accused will not get a fair trial.
Correct. Somebody will get benefit of acquittal, somebody will get the problem of conviction.
So if nobody is touching this, the only thing is that, of course, somebody, of course, they may. The others, if a trial will be a farce.
He says A4 duplicate, so A4 is finished, my lord. He says A3 is an agent, A3's role is more serious. Then A1, A2, then what will happen to A3? What will happen? I don't know.
That is why whenever you are dealing with an application for bail, you should be very careful because ultimately that shall not result in an unfair trial.
Unfair to the victim or the accused.
Both. Fair trial means fair to both. Fair to both.
How is the Maharashtra Police Act different than Makoka?
But it's the same thing. Not Maharashtra Police, not that gets adapted to Delhi as well. It's called the Maharashtra Control of Organized Crime Act. Same.
So same.
Same. It has been extended to Delhi.
Because in the charge sheet I was reading Maharashtra Police Act, not Makoka. Therefore, only for that.
Makoka is not Maharashtra.
No, that's a separate act. Not that's.
Oh.
That's separate. Maharashtra Police Act.
Therefore, I called for that Maharashtra.
That's different.
No, that's it.
That's it. And under 23, my lord, Makoka can be applied only when a senior police officer looks at the papers, comes to a conclusion and passes an order. Sometimes those orders are subject to challenge, my lord, in cases. So it is that kind of a thing. Under 23, that is done. So it is my respectful submission, my lord, that the order suffers from glaring infirmities. One is that it has recorded findings, and two, it has not considered the trial court. Three, it has wrongly applied Makoka, and four, it has wrongly applied parity against the kingpins. And fifthly, my lord, nothing has been addressed to 21-4. These are the various errors, my lord, and I submit this bail should be cancelled. That's message.
Please read 24 also. 21 also.
21-4.
That is fine. That is also to be before
But 23 is the sanction provision where pre-sanction of investigation and pre-sanction where 21-4 is the other one. We've got a copy of the sanction.
No, 21 is 2. 21 also.
21-4 is similar to 45.
Yes. And again 3 says, 21-3 says that 438 is nothing in section is applicable.
Correct.
It's
and thereafter.
Correct.
And 21-4 says not please see where the public prosecutor being.
That is the twin condition.
Yes, well, that's the twin conditions. Here, not please note, it's interesting. Where the public prosecutor opposes the application, court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offence. That's the test. Some places says that he is innocent, but this is not guilty of such an offence, and that he is not likely to commit any offence while on bail. These are the two conditions.
So that whenever an application is considered or bail is considered, the question is 21-4B and the twin conditions are to be satisfied. Yes, sir.
Wait,
But may I take permission?
Yes, sir.
Millets, I need to answer with your lordships 2 questions.
Lordship, I'm sorry, I beg to appear for the stay. We have also filed an SLP that is connected, that's the second matter, and we have sought cancellation of bail also. In fact, we made a prayer before the High Court at the time of passing of the interim judgment to stay.
Just tell us one thing.
Yes, sir.
Whether you are challenging the order or seeking cancellation.
Lordship, we are seeking cancellation.
We put that question bearing in mind the dictum laid down by this court in Papu Yadav's case.
Sorry, Lordship.
In the morning also we said about it. 2005 Supreme Court. Cancellation means any act subsequent to the grant. That means violation of the condition.
But actually, they also
Yes,
challenge.
yes. I'm sorry.
So
I'm
here-
sorry.
Correct.
So that you must understand you are virtually challenging the order granting.
I'm
Order
sorry, Your
granting
Lordship.
bill, if you are challenging it, all grounds or parameters which ought to have been considered, including 21(4)(2), that is still available to be argued.
Correct.
Otherwise, it will not.
That is how it is not between them.
I'm sorry, Your Lordship. I appreciate the distinction.
If no, you are saying without knowing that nice distinction between these two, grant of bail, then yes, then. So, whether you want to add anything to what the London City Council argued?
No, Your Lordships. I just wanted to bring it to Your
You are
Lordship's
endorsing that.
attention
You are
that
endorsing that contention. Yes.
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 Wait, please, minutes. Minutes, maybe it is not relevant that earlier understanding. Since it's been a full-blown argument, let me have my answer to that.
Yes.
Millets, I need to answer two things, Millets.
First of
One
all,
is
no,
whether-
first of all, one thing, we know that it will be a very, very difficult question to you.
Please, Millets.
You are appearing only for one of the accused. Or all the
The
accused.
two accused.
Two
The
accused. Who are
respondents
they?
who had been
Just-
granted bail, A1 and A2.
Yeah, one accused. So that if this order remains intact,
Yes.
3 and 4 already,
Only 3 minutes.
enough. 3 and 4.
What is that the court has said about 3 and 4 is what the query
Yes.
is.
Whether any fair trial will take place thereafter.
That's why, Millets. That's a very
So one
pertinent
part,
question.
one
Very
part.
pertinent question.
Very
Millets.
one part of it.
Yes.
Now we will come to the other.
Yes. Millets.
You need only to argue that.
Yes, sir.
The other one we will take.
Millets. Millets. Let me cite an example in common days, Millets. Not in this country. When it comes to, Millets, any sort of blasphemy. The problem is, Millets, somebody has committed the offense of blasphemy. I go to the court, I go to whoever, the authority, I complain. But I cannot say what's being said. Because if I repeat, that again becomes blasphemy. That's the dichotomy. So, Millets, the mere assertion is enough. He would be sent to gallows. It happens every day in the neighboring country. Because somebody has to accuse the other man of blasphemy. That's enough. Because he can't utter what words he has said. It amounts to blasphemy once again. Here, Millets, every day,
Let's come to the
courts.
matter.
Yes, Millets. Every day, Millets, the courts face this problem, either in High Court or the trial court. Once, especially in a highly contested matter.
No,
Yes, Millets.
You cannot be held to conduct like this
Yes,
because
Millets.
you
No, no,
were
no.
successfully considering the bail applications.
So what I am
also we
submitting
know.
is that, Millets.
And again, see,
Millets.
umpteen number of
Yes.
decisions are there. The only thing is, no, you must be very careful about it. What you
Yes,
are going to
precisely.
say.
Millets, prima facie consideration is required, and usually the courts have a disclaimer saying that this is only limited for the purpose of this one. My lords also do that every day. When it came to that, it should not be taken as an observation by this honorable court that it's on merits. Now, my lords, can we come to para 13 of the judgment, impugn judgment?
Now we are sure
Yes.
about one thing,
Yes, ma'am.
and especially we know
Yes, Millets.
if something which should not have been said,
Yes.
if it is said, not only in one paragraph, in 15, spending 15, 16 pages, and thereafter adding one last sentence, untrammeled by the all above, you decide it. Still, that will weigh with the mind of the trial court.
My lords, may kindly come to
That is why we are very careful about this.
Yes, Millets. I take it.
Then the question is, if you want to say untrammeled by the above, why you made all observation for whom?
Millets. Kindly come to para 13, then I'll explain. That's the way that I could. Please kindly come to para 13 of the impugn judgment.
Yes.
My lords could have it at page 11.
Yes.
It's to be noted that the above circumstances and the facts need to be borne in mind for the limited purpose of deciding the bail application made by accused numbers 1 and 2. I am conscious of the fact that while deciding the bail application, merits of the matter and the credibility of the available evidence cannot be gone into.
No, just one.
However-
no, before reading that,
Yes.
please read the last paragraph which is there in page number 11 of paragraph 12. That also.
Millets may just
In what context the court or in what the court was actually discussing or considering the other aspects. First of all, just read the first sentence in page number 11.
Yes, Mr. Sanjay.
There also, from
The
there.
presence of accused number 1 and 2 and 3 in the office of the collector was for the purpose of the case.
Yes.
It seemed that in the incident of shooting, no role was played by accused numbers 1, 2, and 3.
Yes.
It is seen that the witnesses whose statements have been recorded by the investigating officer have not attributed any specific role or overtake to accused number 1 and 2 at any time. This is what's been observed. Now, Millets, before your lordships, the charge sheet is there.
Above circumstances.
Yes, Millets.
So the court was of the view that they were there solely for the purpose of conducting the.
Yes, Millets.
Yes.
May I answer that two things, Millets. One is that the observation concerns their presence in the collector's office on the day when the incident took place.
Yes.
And it's been caught by the CCTV camera, etc.
Yes.
Indeed, they could not deny the fact that they were not at the scene of offence. Instead, they were there. Of course, Millets, the plea could be on their behalf that based on your instructions it's being carried out. It's a different story. But the observation has been confined to the fact their physical location at the time of event. It was at the collector's office. That's been observed. Right now, Millets, let's see the second one.
One
Yes.
more aspect you may have to.
Yes, Millets.
No, here the High Court arrived at a specific finding. It is not a simple observation. A finding. That's an
Finding.
evidence. That
On the
is, it
purpose
is
of bail, Millets. May I add that qualifying statement? The finding.
we will say in our judgment we will say.
It's almost impossible.
In our judgment we will say
Sufficient.
definitely.
Yes.
Now we will read it.
Yes.
You can decide
Yes.
whether it is an observation or a finding or a conclusion, whatever it be.
Yes.
But whatever be the way in which we are describing that, it is this. We will read like this. The evidence on record.
Yes, Millets.
We do not know what is the evidence.
It's there before your lordships. They've not read though. I will read. I will take your lordships through.
Let us see.
Yes.
Evidence on record would further show
Yes.
that deceased had settled the dispute with the accused numbers 1 and 2 and
Yes.
the members of family.
Yes. May I just read Millets?
Yes.
This is what they've said, Millets. It's been said on, as my lords have indicated to me, that page 11, the first few lines of para 12 talk about only two things.
Yes.
One is their physical presence. It's a matter of record. And the second one is that, Millets, that no witness spoke against 1 and 2. These are the two things, Millets.
Yes.
Millets, what's been said, they have taken your lordships to two documents.
No
May I just take
specific
the-
overt act.
Yes.
That is what.
Yes, Millets. Millets, my lords may kindly appreciate, this is in the backdrop of one thing, that I was inside for 3 years and had been granted bail, and the last 10 months I had been enjoying that freedom.
Yes.
In that context, they have come with your lordships, and your lordships indicated many a time, if not in this case, in every other case too, that unless there are compelling reasons, the discretion exercised by the courts, including the Honorable High Court, it need not be interfered with. That's why, Millets,
That is applicable to the
petitioner
High
has
Court
gone on
also.
saying,
That is applicable to the High Court also because
yes, indeed, Millets.
when in an
Yes.
application, when the trial court
Yes, Millets.
made observations and passed an order, if there is
Yes.
a plausible view,
Yes.
the question is whether the High Court is.
The second factor, Millets. The
That
second
also.
factor is that, Millets,
Yes.
A3 was granted the bail,
Yes.
and that's been challenged before your lordships, and that was rejected. My lords could have the order,
Yes.
order copies, Millets.
P9. That was an order passed in February 22.
My lords may have a look
Is
at
it?
Millets.
The order dated 25/2.
Yes,
Is it so?
Yes, Millets. It is. So, Millets, this is the backdrop that has to be, in my humble submission, to be considered about whether it has to be cancelled.
Yes.
It's not a standalone case, Millets.
Yes.
So, Millets, then the Honorable High Court has done one thing. It has compared the material against A3 and A1 and A2.
Yes.
Millets, though the petitioner has gone on saying A3 is my agent and my agent only protects me.
Yes.
Millets, not at the cost of incriminating himself. And Millets, then how about the witnesses that have been examined before charge sheet was filed, be it 161 or 164? That may also have to be gone into, Millets. My lords, my kindly, Millets, they themselves filed very recently, last month, an interlocutory application. Kindly have a look at it, Millets. I'll give the number of that one. That is IA number 16632 of 2024. Kindly have it. Because they themselves have annexed a statement of an eyewitness to the incident, in the sense that of the compromise. Who has the motive? Well, it's IA number 16632 of 2024.
Not here. 100 is not.
16632, correct?
Yes, indeed, minutes. 16632 of 2024.
Yes, sir.
They filed it. Minutes.
Is there?
Another one could be supplied, minutes, if my lords.
No, we have it.
Yes.
Only one.
Can we borrow yours?
Yes, indeed, minutes. Yes, give it. Sometimes the borrowing becomes a lifesaver, minutes.
But somebody will land in trouble also by borrowing.
Yes, minutes.
Anyway, please.
Minutes got the copy.
Yes.
Yes, minutes. Now, minutes, kindly come to page 30, where the statement of an eyewitness has been annexed by them, who's been examined as we call it, minute, listed witnesses. Page 13 minutes. It's a statement under section 164. Subsection 5.
Statement number 164.
Indeed. And the name my lords could see, Rahul Degade. May I invite your lordships to the next page, minutes?
Page number?
Minutes, page 14, kindly see para 1 that lays the foundation. Page 14, para 1. May I read, minutes, with my lords kindly?
Yes.
The Kamble family's approximately 10-acre Mahavatan land in so and so.
First of all, who is this person?
Minutes is one of the witnesses. And he's a companion or close aid of the deceased. That's what's come to.
Yes.
My lords could see.
Who is in the list of witnesses?
Yes, minutes. One and two paragraphs will illustrate the whole thing, minutes, very, very clearly. The Kamble family approximately 10-acre Mahavatan land so and so. The regularization process for this transaction was also completed. I learned this information from Rajesh Kanaba, with whom I had a good relationship. There was an ongoing dispute between the Kamble family and Kanaba, that's the victim, regarding this land, and cases were pending before the sub-divisional officer, Mr. Rahul Kamble, Rupesh Kamble, that's us minutes, and their friend Mr. Ganesh Kure were handling the related work. My lords may kindly see the next paragraph. It's of importance in my humble submission.
So,
regarding
as
the same,
on 24/11/2020 also there was an ongoing dispute.
yes, minutes.
Going by him.
Regarding the sale of, may I just read that paragraph 2 minutes? Regarding the sale of the Kamble
The
family.
death was on?
Millers, the death was on 5th Millers
5th October.
5th October 22.
incident. Millers, 5th October 2020. That was the incident.
Yes.
May I proceed, Millers? Regarding the sale
So
of,
this was thereafter.
Millers, he talks about the incident before that.
No,
As
but
he-
you only
Statements during the course of investigation.
You only said This was under 164 recorded on 24/11/2020.
Indeed.
On that day, 24/11/2020 also he said ongoing. Dispute was there.
Yes, my lords.
Yes. No, the High Court held that
It's still
no,
been-
it was settled. That is why.
That's why, my lords, I am reading.
Ah.
This is the statement that led the observation, that laid the foundation for the observation. Can you see para 2 minutes?
Yes.
Regarding the sale of Kamble family's Mahabad Watan land to Mr. Rajesh Kanabar, there were around 3 to 4 meetings involving Rajesh Kanabar, myself, and Mr. Ganesh Kure.
Yes.
This Ganesh Kure is here 3.
Yes.
Mr. Ganesh Kure negotiated for around 10 crore rupees for the transaction.
Yes.
But Mr. Rajesh Kanabar was willing to pay 9 crore rupees.
Yes.
The Kamble family members were to receive the money via check. But Mr. Ganesh Kure would not receive any amount.
Yes. Yes.
Millets? The observation is that, Millets, when there was a settlement.
No, negotiated.
Yes, Millets. When there was a negotiation, my last
No settlement.
when there was a negotiation, we demanded through A3 10 crores. He agreed to pay 9 crores. And we agreed that 9 crore is enough for
No,
us.
that is not what.
My last my courtesy.
That is not what the document.
Yes. May I just read that? May I just read that?
Uh-huh.
May I read that?
Please.
But Mr. Rajesh Kanabar was willing to pay 9 crore rupees. The Kamble family members were to receive the money via check.
Yes.
But Mr. Ganesh Kamble would not receive any amount.
Yes. Now read the next sentence.
Millers. Despite the agreement for the sale of land, the Kamble family continued their cases.
No agreement.
in
Where is
court.
the agreement?
Yes, Millers. Despite the agreement for the sale of the land, the Kamble family continued their cases in court and before sub-divisional officer. I had a very good relationship with Mr. Rajesh Kanabar. Due to the continued harassment in ongoing legal cases despite the settlement, Rajesh Kanabar decided to sell 10 acres of land. On 5/10/2020, I informed Rajesh Kanabar via WhatsApp message around so-and-so, I will be visiting his office around so-and-so. Prior to this, I had informed Rajesh Kanabar that I would meet him on so-and-so. It goes on like that, Millets. This is just next 2 sentences.
So
Millets,
that where is the specific agreement
beg your lordship.
which would reveal that the entire dispute was settled?
Millets.
This would only give otherwise
Precisely,
because
Millets.
despite that,
Millets.
if at all an oral agreement may be there,
Yes.
we do not know. But
Yes.
here
Yes.
it says that he continued.
Yes.
The legal case continued.
Yes, Millets.
So there was nothing
Millets.
before the court to arrive at
The
a finding.
investigation, as has been reflected in the charge sheet, I'll take your lordship to that one.
We are only on the court.
Exactly.
See, the court could not have.
Based on,
Relying on this,
Yes.
no court could say that the entire dispute was settled.
no Millets. As far as we are concerned, we were willing for that purpose, but
Yes,
Millets,
no, that
the
is why.
motive that
No,
impelled.
that is why
Yes.
we took you to draw your
Yes,
attention
Millets.
to that.
Yes.
Based on evidence on record,
Yes.
the matter was settled, indisputably settled.
Millets, I'll come to the rest of the
How can
material.
it be?
Millets, this is one statement. That's why, Millets, I'll
Then
take
let
your
us
lordship
see.
to the charge sheet as well. So
No,
that,
there-
Millets, I just will have, because Millets, I began with 2 submissions,
Yes.
Millets. One is that whether Makoka Riga would
We
apply
are
to
only
me.
on the other one.
Yes,
The
ma'am.
conclusive finding of the High Court that it was settled.
Yes,
Evidence on record, indisputably.
Millets. May I submit, Millets?
That cannot.
The
Yes.
observation is in the context of a bail application. Second thing, Millets, then I will take your lordships to the charge sheet as well, because my role has
So
to be
no other
looked into
person had
based
spoken-
on the statements
no
of the
other person
witnesses.
had spoken about the negotiation.
He
Can
alone
be,
is the
no, at best one can say that
Yes.
there was a negotiation and unsuccessful negotiation.
yes, Miller's prosecution witness, who was an eyewitness, speaks about it. That I was happy with regard to that amount, but he felt that I've been doing the whole battle, I've been left out. This is how next step, Millers, I'll take your lordships to. Now, Millers, now let me address, based on this one, how things have shaped. Then finally, Millers, I'll take your lordships to
So the foundation
judgment
is
that's
not,
been issued on the
foundation
previous
for
one
the
too.
order
Yes, Millers.
of the High Court is not absolutely incorrect.
Yes, Millers.
Incorrect. It is unfounded.
Millets, I'm not on that point at all.
Yes.
What's been said is that, Millets, the motive and the role that I've played, prima facie, to earn a bail is the question of your lordships.
Yes.
Millets,
Now,
and then the role that's been played and the evidence that's been gathered vis-a-vis A3 damning in the sense he contacted the gang, he executed the whole thing, he has overseen. Then Millets, the question was, why did he do it? Did he do it on my behalf? Is the only question.
We will put a very, very
Yes,
innocuous, appears to be innocuous question. We do not know whether it is.
So be it, Millets.
Who was to, if the agreement fructified,
Yes.
who was to purchase the land?
The victim.
Victim.
Yes. The victim has only an agreement of sale.
And from
And
whom?
he has filed a
From
suit for
whom?
injunction.
No, from whom?
And Millets, from me. I am the landowner. I am a farmer. I am not much educated. I requested A3 that please take care of this one. I don't know anything about these things.
No,
I am pitted against a builder.
Mr. Naidu, the matter was going on. When was the matter filed by the victim? When was the matter filed by the victim?
2000. Millets, it was in 2007.
So he was pursuing that.
Yes, Millets.
Talks of settlement took place.
Millets, yes. I mean, only thing is that, Millets, I own the land.
Talks of settlement took place.
Yes, Millets.
They did not fructify.
Yes, Millets.
The charge sheet discloses that when the talks failed, PW3 contacted PW4.
That's the prosecution version. I'm not contradicting.
We are only on
Yes,
that.
ma'am. All the time.
Therefore, all of you were present at the spot when he went to attend the hearing on 5th.
Yes, Millets.
When he went to attend the hearing.
Millets, he left the place. It has not happened at the collector's office. He left the place and he has gone elsewhere to buy fruits. By then we were not there. The gang came, they shot. A4 came and they shot him. And then Millets, he was in the company of other accused, not me. For that purpose, Millets, I will just take your lordships to two aspects only, nothing more. Millets, if I'm not repeating, it is in the context of bail granted to someone not being granted to me, if at all, then what could be the distinguishing factor? That's all my lords would be looking at. For that purpose, Millets, let me submit. What's been said by them is, last thing first, that Makoka squarely applies to me. And they have said, Millets, the moment it does not require, as to the charge sheet being twice over, once I assist or whatever I do vis-a-vis a gang, I am in. This is what they have said. May I just take your lordship to the definition and see that how it applies to me. Should I just Millets? Kindly have that act.
Which provision?
Makoka.
Organized.
Yes, Millets.
Organized crime.
Organized crime, Millets. Kindly come to section 2, subsection D or clause D.
Yes.
May I read, Millets, if my lords have it? Continuing unlawful activity.
Yes.
Means an activity prohibited by law for the time being in force, which is a cognizable offence punishable with imprisonment of 3 years or more, undertaken either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate in respect of which more than one charge sheet has been filed before a competent court. My lords may kindly see. If I am part of the gang, that's curtains. If I am not, but if I undertake an activity on their behalf, then I should have had an antecedent of another charge sheet. Otherwise, I cannot. Here, the allegation is not that I have undertaken their task, an extended arm of a gang. The allegation is, it is I who commissioned, if it were to be.
That is why we said.
I am coming there.
See, after considering all the provisions of Makoka, this court already said, no provision, not even a single word in this act, should be considered in isolation. because this was enacted with a purpose.
Precisely.
So that should be borne in mind while construing any provision.
Yes.
And now 3.2 also, that is why we say,
Yes.
please read 3.2 also.
Yes, Minister. I'm just coming to that. I'm only taking your lordship through them and to put my spin on that if it's permissible.
Yes.
Nothing else, Minister. Millets, which more than...
Provided it is a spinning track.
Indeed, Minister.
Question whether it is in Chepok or in other place.
Yes, Minister. Which more than one charge sheet have been filed before a competent court within the preceding period of 10 years and the court has taken cognizance of such offence.
Yes.
Then, Millets, it defines what amounts to an organized crime. Organized crime means any continuing unlawful activity by an individual, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate, by use of violence, etc., for the gain of pecuniary benefit or gaining undue economic or other advantage for himself or any other person, so and so. Then, Millett, the syndicate has been defined in F. So, organized crime syndicate means a group of 2 or more persons who, acting either singly or collectively as a syndicate or gang, indulge in activities of organized crime. Let me come to section 3. 3.1. Whoever commits an offence of organized crime shall, subsection 2.
That is direct involvement.
Yes, miss. I'm coming.
We need to
Whoever
Yes.
Whoever conspires or attempts to commit an advocates, abets or knowingly facilitates the commission of an organized crime or any act preparatory to the organized crime shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also be liable to a fine, subject to a minimum of fine of 5 lakh rupees. My lords, my only submission is that, Millets, 2 and 3 have to be read conjointly. And your lordship, it is not recent extra. Your lordships have already read that one. Let me pass it on. An identical question has been posed with your lordships, and that's been answered. So these 2 things. It's a short judgment, Millets, of recent vintage. That's 2022-13 SEC 817. That's been reported, Millets. I have given the
2023.
2022 13 SEC 817.
Yes.
May I just read the 3rd paragraph, Millets? Because that's where the submission begins. Not to repeat the name by mistake, Millets, I blocked it. So that subconsciously too, I will not do that, so that there will not be any controversy. Because after all, we need to do our duty, Millets, when it comes to arguing your point.
That's other thing.
Yes, I'm just reading.
Sometimes you will be here, sometimes you will be here.
Exactly, Millets, exactly. For that purpose, Millets, I'm telling. Perhaps I may be stealing the labor of the learned senior, nothing else. Let me read that.
You are trying to read the
May I read,
efforts
Millets?
read the efforts of the analysis.
It doesn't have the pagination, I believe. Let's kindly come to the next page. That begins with the learned senior counsel's name.
You know.
Mr. So-and-so submit that for invoking the provisions of Gujarat Control of Terrorism and Organized Crime Act 2015, which is analogous with the Maharashtra Control of Organized Crime Act. Millets?
Yes.
2 requirements have to be satisfied. The first one is that an activity undertaken is either singly or jointly as a member of an organized crime syndicate or on behalf of such a crime syndicate.
Yes.
Now my last mechanism is the next one. The second one is that in respect of such an activity, more than one charge sheet must have been filed in the preceding period of 10 years.
Yes.
Mr. So-and-so submits that in the present case, the second requirement is not satisfied.
Yes.
He submits that in the chart wherein all the crimes registered against the petitioner applicant have been listed, it could be seen that only FIR number so-and-so dated so-and-so is in respect of an activity committed by 2 members of the syndicate. He therefore submits that the requirement of filing of more than one charge sheet is not satisfied in the present case.
Yes.
I believe, Millers, I stand in a better footing.
No.
I'm coming.
That is why a particular point which most probably might not have been arising for consideration in that particular case and therefore might not have considered.
Let me submit.
But here, No, in respect of a person to say that a person who had involved in this continuing, continuing unlawful activity.
Yes, minutes.
And whether he is a member of organized crime.
Yes.
But in a case of a person who abets or who conspires, whether this condition can be satisfied.
After yes, minutes.
No, that was not a point which
we have not come to
let
that.
us take us through that.
Yes, minutes. Minutes. It's just three paragraphs.
Yes.
Nothing else. Then minutes, I'll go back and I'll answer that question since it's been posed by you
whether it was
in the context of the provision itself.
Whether in this particular case that question was considered.
May I submit minutes?
No, we only wanted to know.
May I submit
whether this was considered. No.
I'm just coming to that.
Please take it.
May I submit minutes?
Because understand.
One factor, minutes.
It's not a hearing day.
No, minutes.
Of course.
For that purpose, minutes, my lords may kindly appreciate on the last occasion, the understanding was that it was confined to parity. But now since I've argued, I need 2 minutes. Kindly appreciate only one factor, minutes. Why I need to beseech with your lordships is that, minutes, my liberty is at stake.
Yes.
If at all, on the converse, minutes, I could say that all right. But me, I have to go back to the gallows or to the jail for that matter. And
not
that's
gallows.
why minutes have been making.
Not gallows.
That's why I corrected myself. They don't mind sending it. Right? Millers. For that purpose, Millers, I just needed your lordship's indulgence to run through my material. That's the only purpose. May I say, Millers, after taking all your lordship's time up to now, since it may take a little more time to crave your lordship's indulgence, it could be posted even on a Tuesday for me to argue. Millers, I'm only suggesting, I'm not running away in the sense, whatever the time, I just impress on your lordships the need for not to reconsider the one that's been well reasoned. I'll come to that based on the material. Nothing else. Let me read the next paragraph.
Please read.
Yes, Millers. Millers, that in the present case, the second requirement is not satisfied.
Yes.
He submitted to the chart wherein so and so. Then further submits that paragraph. Oh, sorry, next one. There's no paragraph. Yes. Further submits that the petitioner applicant has already been released on bail in respect of other FIRs, only on account of him, along being implicated in FIR so-and-so, under so-and-so, he is deprived of his liberty. Now, Millers, my lords may kindly come undisputedly. My lords could find that one?
Which one?
After 2 paragraphs,
Yes.
the next page, undisputedly.
We have it.
Yes, ma'am. Undisputedly, the perusal of the chart would reveal that only one offence, that is so-and-so, would show that it has been committed by the 7 accused, out of which 2 are the members of the syndicate.
Yes.
In respect of offences at serial numbers 1 to 4 in the chart, no member of the syndicate are rated as accused.
Yes.
We are of the prima facie view that for invoking the provisions of the so-and-so Act, the following conditions will have to be fulfilled. That such an activity should be prohibited by law for the time being in force, that such an activity is a cognizable offence punishable with imprisonment of 3 years or more, that such an activity is undertaken either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate.
Yes.
This is where, Millets, I may have to lay emphasis on. Then, Millets, that in respect of such an activity, more than one charge sheet must have been filed before a competent court. So, Millets, I need to satisfy either straightforward that I am part of the organized gang, or else, Millets, I should be undertaking an essay or an assignment that I will be doing that diktat, and if at all I come to the second limb, then there should have been a prior instance twice over.
Yes.
Not a singular instance. In this case, there was a singular instance. Millets. That the charge sheet must have been filed within a preceding period of 10 years.
That is because of that. I know what we want is, of course, we will hear you.
Yes.
There is a distinction between these two. A person who will squarely fall under the definitions under unlawful, continuing unlawful assembly.
Yes, Mills.
Organize the crime,
Yes.
organize the crime syndicate, etc. And a person who abets such a person. That means a person who falls within these.
Yes, please.
And somebody abets or conspires with such a person.
Yes, please.
There is a difference. That is why, precisely after going through everything, we put, even when the Senate Council was opened the argument, we put that question. Now, why don't you read 3.2? Because 3.2 is different. For a person who falls under 3.2, he need not satisfy these conditions. Question is whether the person with whom he conspired, whether he satisfied this.
May I read 3.2 once again, Mills, and
There
go
is
back
a
to the
distinction
definition?
between these
Because
two.
since you
That was
said
not
that,
a point which
Mills,
was considered in this
Mills,
case.
first of all,
That point was not considered in this
Mills, may I submit?
Yes.
First of all, I should be in the dragnet of that definition, where that either I should be part of the organized crime syndicate or I should be doing something at that BD.
No.
No.
Now we will say.
If I don't come under that.
We will stand definitely stand corrected if now we are convinced. But now 3 and 4, going by the findings of the which is in your favor, which you are earnestly trying to sustain that order. Even in that order, what is the finding? A3 committed the.
Yes.
He killed the person.
Yes.
No, A4. A3 also. No, he is the agent. Now suppose if A3 and A4 falls under this, satisfies these other definitions. And if it is something, we only say something in the evidence which would show, prima facie show, you conspired with them, you abetted them, then we need not go into the other things. That is our understanding of
Let me answer
this.
this. Let me answer. My lords have said, anyway, A4 is the kingpin or the head of the organized crime syndicate. Now the next question is, A3, his friend, and he has associated.
Understand, otherwise
Yes.
we will be failing in our.
Yes.
Why we put that question is,
Yes.
virtually you are also agreed by that findings against A3 and A4. Because A3 and A4, if this is the finding, if they falls under those within that particular process, if there is something to show that you conspired with them.
Yes. Miller, there are two things to look at.
That
yes.
is also against.
Millets, here two things my lords may have to look at. One is that, Millets, whether A3 was treated judicially, either by your lordships or earlier by the High Court or by the trial court, as having been within the rigors
A3 is
of
not
this
before us.
provision.
A3 and A4 are not before us now.
No, Millets, A3 got the bail and A3 faces the same Makoka 21-4.
What is the role of A3?
Millets, the finding is, as in the charge sheet, entire role is his. Because he took over, because he wanted his pie, a share in the pie, and he would not get it. That's why I am taking that, Millets. So that's why, Millets, they have said, I have nothing to do, I have no contact with them, but he has organized, he has orchestrated, he has done everything. That's how, Millets. Despite that finding, despite that finding in the investigation as reflected in the charge sheet, he was granted the bail.
Yes.
And my lords have said that we will not interfere. So that in that context, I say, Millets, my lords have put a question to me.
As argued.
Yes.
Now, by saying that we never want to say the name of the counsel who argued in this case, you can say that those two judges were there who passed the order. We will not say who were there.
Millets, what I have said is this, Millets. If at all I am on a par with A3, nothing more to distinguish.
Because one of the two.
Yes, Millets. If I am on a par with A3, Millets.
Two who ordered the other order, presently here also. One is here.
Yes, I know.
Yes, then.
I have seen. Millets, if at all I am on a par with A3, I have got the advantage of parity. Nothing more to distinguish. Then they could have been attempting to show that my position is much worse or much more aggravated. That's why I cannot be given that benefit. This is all. Ultimately, it boils down to only that, Millets. Whether I have a role which predominates and puts A3 in shadow. This is all I need to answer. May I take your lordship to the charge sheet? Let's see, Millets, what the witnesses have spoken
your
about,
attempt is to
the
say
roles
that a
that have been
person
attributed to me.
who is attributed a greater role or a very serious grave role,
Yes, Millets.
he
There
was
should be
granted,
Millets.
he was granted bail,
Millets.
and the application for cancellation of his bail was not interfered with,
Millets.
and therefore, being persons whose role is much lesser than that person,
Yes,
therefore there is nothing to interfere with that.
Millets, that's why, Millets, this is the only thing before your lordships. Whether I can be equated with Yetri and given the advantage because he has got the bail that has attained finality, or whether my role is distinct and there is material to justify that one so that I do not be given that advantage. That's why, Millets, since they have begun with the trial court judgment, what they have said is that, Millets, that before the trial court, when they applied for the bail, rather when we applied for the bail, they opposed it, and the trial court has taken the question and rejected the bail. But High Court has referred to the charge sheet and other things and has come to a different view, so that is perverse. This is what they have said. Kindly come to what they have pleaded, even in that order as has been recorded. May I take your lordships to plus 226? That's where the order is. That's how the petitioners have begun. Millets have come to that.
Yes.
Kindly come to page 227. It is their own pleading, Millets, para 5.
227.
227, para 5 extracts the defense on the part of the petitioner opposing my bail. My lords could see.
Yes.
Despite the settlement talks, the applicants at the instance of accuser number 3 continued litigation. Kindly relate this to 164 statement.
Before reading that,
yes.
Read para 3 also.
Yes, Mills. The applicants had hired accuser number 3, Ganesh Kure, to get back the land from the deceased and to sell it out for a higher price. The accuser number 3 was continuously with Kamble family and helping the family to file the contest several proceedings against the deceased before different forums, including civil and revenue courts.
So applicants means you.
Yes, Millets.
You hired
it's an admitted fact. It's an admitted fact because I'm a farmer. I'm not well versed, not much educated. We brothers, we have asked him, who is otherwise worldly wise, at least I believed, that you please pursue my litigation. And he pursued. What they say is that it is who masterminded all the proceedings. He continued multiplying litigation.
For whose behalf?
Yes, on my behalf. On my behalf. That's why let's kindly read this one. What they themselves say that.
So he continued the litigation.
On your behalf. No, the converse is that para 5.
Yes.
Para 5 says, despite the settlement talks, we continued the litigation at his behest.
Despite the settlement. It
yes.
Is not so. Settlement talks.
Yes, Millets. I do repeat, despite the settlement talks, we continued the litigation for what? At the behest of or at the instance of accuser number 3. This is what precisely the witness has spoken in 164. Yes. This is what he has said. Now, Millets, let me come to the next part. Yes. Kindly, Millets, investigation para 7. May I read, Millets? Again, is there on...
Just
Para 7. During the investigation,
Yes.
it is revealed that conspiracy was hatched to commit murder of the deceased by the applicants, accused number 3, and members of organized crime syndicate headed by accused Hashim. This is what they have said, Millets. My last may kindly come. The next Millets. Millets.
Yes.
Page 50, para 15 Millets.
Yes.
At page 231.
Yes.
Millets, from the statements of witnesses, namely so Amol Chavan and Rahul Dagadi, that's what I've taken your lordships to. It can be gathered that the settlement meetings between applicants on behalf of the Kamble family and deceased took place several times. In the statements of Sanjay Badane, it specifically stated that both applicants used to go to the office of the deceased for settlement talks. Witness Rahul Dagade has given more details. That's why Millets have taken, because he was the eyewitness.
Yes.
Then Millets, para 17 minutes.
Yes.
Although settlement talks were going on, the applicants and accused number 3 approached different builders with a proposal to sell the same property. They had approached builder Ashok so-and-so with a proposal sale of the property. Even a part of the land was sold out to so-and-so. A civil suit in this regard bearing CS number is pending between so-and-so. Millets. Now Millets, my last mechanism, next paragraph. The deceased had filed civil suit for injunction and was also fighting the case before Revenue Authority. The orders of judicial forum were turning in favor of the deceased, and it was a cause for frustration of the applicant. It's necessary to note that the applicants were attending all the hearings in respect to dispute property on behalf of Kamble family, along with accused number 3. My lords, may kindly see. Here,
now we will now
there are 2 minutes.
One aspect,
Yes.
which is of a great importance is
Yes.
you virtually engaged, or rather, case of the prosecution. We are only saying that. Hired the service of accused number 3 for what purpose?
For the purpose of litigation.
Let us see.
Yes, ma'am.
We'll see.
I have hired
That
not
is why-
now.
no, that is
a
why-
decade ago.
One thing.
Yes.
Just wait.
Sorry.
That is why we will read para 3 again.
Yes, ma'am.
The applicants have hired accused number 3 Ganesh so-and-so
Yes, ma'am.
to get back the land from the deceased. So as of now, the property was with the deceased. You want it to get it. You want to get it back. No, say.
Yes.
And thereafter, for what purpose? To sell it out for higher price. So here, whose interest? To protect the interest, to protect everything, the demand of 1 and 2, you yourself hired the service of that person, and he was there not to safeguard or not to do something to protect his right or satisfy his right. He was there because you hired his service going by the prosecution. If that is the case, that is the
That was
that alone can be looked into as that alone can be looked into as if that is the case of the prosecution case. How you can say that we are our role is lesser?
With great
No,
respect.
it is your interest.
Millets, with great respect, that is not the prosecution
Don't try
version.
to- don't-
That is the complainant version. Please, Millets.
What else we can?
This is
What
the
else we
complainant
can?
version, not the prosecution version. I'll take to the charge sheet. Millets,
Now, at
ultimately,
this
my
point-
word or their word.
Understand one
Yes,
thing.
please.
We are not here or the High Court or the trial court was
Yes, ma'am.
conducting a mini trial.
Yes, Millets.
We only wanted to know what exactly is the case of the prosecution, whether any prima facie materials are there
Yes,
for making you people, that is 1 and 2, stand the trial. That's all.
Millets, kindly come to page 121 so that I could go to that
Not
one.
the other way. This is the way.
My lords, may kindly come to that one.
Page number?
121, that's where the charge sheet begins.
Yes.
Is it the charge sheet? Please take
Yes.
it. I'm just taking your lordship to that 1 minute. I'll go to it. Millets, my lords got it?
Yes, yes. One 21 is the translation.
Yes. Millets, may just beg your lordship's pardon. Kindly come to 114.
What? Yes. What is that?
114, it starts minutes.
What is that 114?
Charge sheet minutes.
But kindly come to 191. Huh?
Yes, minutes. I'll come to that one minute.
No, that's really where prosecution version.
Yes, minutes.
190, 194. That's where really the prosecution version.
Yes, minutes. Now, minutes, kindly come to 194.
114 is not the.
No, minutes. 194.
114 is not the
Minutes.
charge.
194 minutes. 194.
Not the charge.
My lords have corrected me. 194. May I just read minutes?
Please.
Charge is that the offence has taken place within the limits of this honourable court and so and so, so and so, so and so. Accused 1 and 2 in this offence and their common family own lands bearing number so and so, situated at so and so, so and so. Well, in the year 1989, it all began in 1989.
You had, he had you had sold the land to him.
Well, there's no sale, it's an agreement.
Agreement, correct.
Yes.
He was in possession.
Yes, minutes.
A dispute arose. He filed a suit for injunction.
No specific performance, only injunction.
Correct, injunction.
Yes, minutes.
And he was sitting in
Then,
possession.
then what has happened?
Therefore, you wanted the land back.
Millets.
And since you couldn't get the land back, you contacted number 3.
Millets, kindly.
You contacted number 3.
Kindly
and
appreciate
number 3 on your behalf with your. That's what the prosecution.
I'm coming to that. This is the charge sheet.
On your behalf,
yes.
Number 3 contacted number 4.
Millets.
And therefore,
Nice
all that was being done with your knowledge.
Yes, exactly. Millets, there should have been one witness who spoke about that one. My lords will appreciate that we are not in section 202 of Contract Act to fix the agency. It is under a penal enactment where vicarious liability, unless statute says 120B, that's the only thing that stands against me. Now, Millets.
And they have said that at the spot of crime or close by,
yes,
say food vendor,
yes,
you were there.
I'm not there. I'm not there with
conversations, telephonic conversations.
I was not there at all. It was A4 who did that one. I was nowhere to be seen except in the collector's office.
Telephonic conversations.
No. Millets. That's why Millets have come to the final crux.
That's what the prosecution case is.
No, Millets. That is the version of the complainant, not the prosecution. That's why, Millets, I am taking your lordship the prosecution.
Yeah.
Whether I have got such a role which is explicit and one witness spoke about me, this is the one that should clinch the issue. My last may kindly come to. Millets, it all began in 1989.
Is guaranteed.
Millets.
We will not make any observation as has been done by the trial court and high court.
Yes, Millets,
and
precisely.
That, you did this role, this is your role, you played this, you are...
No, Millets. Millets, in charge sheet has been filed.
Mr. Naidu,
Millets.
page 199 charge sheet.
Yes, Millets.
On the day
Can I go to that, Millets?
On the day of the incident,
yes, Millets.
5th of October 2020,
yes.
page 199.
Yes, Millets. Before that, I just crave your lordship's attention to page 195.
Will you just
read
this first?
Yes, Millets. I am reading that.
Page 199.
Yes, Millets. I am at 199.
Kindly read it.
That's about the incident.
Kindly read it.
I'll read, Millets. On 5th October 2020, the builder in this matter, so and so.
No. I think your pagination and our pagination.
I believe, Millets, 199. It begins with the word on the day of the incident.
On the day of the incident.
Yes, Millets. And your lordships have said, should I begin from that one? On the day of the incident, 5th October 2020, the accused numbers 1 to 3 were present in the office of Collector Pune relating to the matter for hearing, and accused number 4, Hashmukh Patel, had arrived there. Accused number 6, Rohit Yadav, and accused number 8, Rakesh Bhutte, were designing the plant at the spot with accused number 7, Rajesh Salunke.
Correct.
Right, Millets. Now, my last may kindly see. Should I continue?
Please.
On 5th October 2020, the builder in this matter, so-and-so, aged so-and-so, residing at so-and-so, had come to the office of the Collector Pune in the matter of case of which appeal was filed by Kamle family, and after having completed the work there, in the afternoon about 2:45 hours, he was purchasing the fruits near the footpath of State Bank of India gate, which is adjacent to Collector's office, and that point of time, the accused number 4, with the indigenous pistol,
killed him.
Rajesh so-and-so was taken to Jahangir Hospital by the car of the complainant so-and-so, where his person was declared dead by the doctor so-and-so.
Yes.
Then, Millets, may just continue. The body was brought in Sassoon Hospital and inquest punchinam of the deceased were carried out under so-and-so. And the post-mortem was done, and reason for the death in the certificate was mentioned as shock and hemorrhage due to so-and-so. Millets, having read this one, let me see, Millets, what preceded this as per the investigation. May I take your lordships back to that one, Millets? May I just read minutes before that, page 198, since we have come that far. 198 minutes. May I read minutes? Page 198.
He says, yes.
Minutes.
We'll
This
only-
is Rajesh so-and-so.
We'll only request you to finish it now.
Yes, minutes. This is Rajesh so-and-so was attending meeting with accused number 1 to 3 relating to the dispute of subject land and simultaneously was also taking legal action relating to this property. Rajesh so-and-so and got the order of subdivision officer so-and-so in his favor, which was the understanding of accused, and therefore come the family and the accused, minutes, come the family and the accused 1 and 2, and also on their behalf, the accused number 3, Ganesh Kirware, irritated upon Rajesh and so-and-so. My last make I appreciate minutes. He had, based on agreement of sale, the records, revenue records mutated. I have filed an appeal before the collector. I have got a stay. I have annexed that before your lordships. I have got a stay of all the proceedings. Now let me read. Very good. Accuser number 3 in this matter, Ganesh Kure, met the accuser number 7 in this matter, Rajesh Salunke, and he had briefed him is this matter, and accordingly accused number 4 had designed the conspiracy in collusion with accused number 4, accused number 6 and accused number 8, and gave instructions to accused number 4, Hashmukh Patel, to kill the builder Rajesh so-and-so.
Yes.
Well, this is what the allegation about
now,
3.
now come to 203, the last para.
May I come to 203 minutes?
Last para.
I am coming to that minutes.
That is
1 minute, minutes. 203 minutes. The last. In such a way, the accused 1 to 8 have created the threat and terrorism, and they have committed the organized crime unlawfully for their own economic gains, and for that purpose, they are using the fatal arms and with common intention of creating threat. They have created the fright, fear, and terrorism in the minds of people in collusion with each other, and the gang has designed and organized the criminal conspiracy, etc. My last may kindly appreciate minutes. When it comes to the role of
Just one.
yes, ma'am. Let's kindly appreciate minutes so that I can hold it up.
Now,
Yes.
our understanding of the issue.
Yes.
Only the case of the prosecution, pursuant to the execution of an agreement,
Yes.
the possession was parted with, or the possession is, or rather was in the hands of the deceased. 1 and 2, the vendors.
Millers, their extent is Millers, I am told on instructions,
whatever it is.
700 square yards.
Whatever
It
it
belongs
is.
to the whole of the others.
Let us see.
My stake is 700
No, we
square
are
yards in that
we are
one.
only
But
saying-
we have been dogged because that's all I have been left with.
We are only saying the
Yes,
case
please.
of the prosecution.
Yes, Millers.
1 and 2 want to get back that property for the purpose of selling it for higher prices.
Yes, Millers.
For that precise purpose, you engaged 3, who in turn engaged the other,
Millers,
contacted the other
may I
person.
submit, Millers?
And then-
I engaged 3 to litigate on my behalf, and this is a decade since. Not that I did it
Understand one
overnight.
thing, he is not a lawyer.
No, Millers, I need to have somebody who is
And
worldly
what-
wise.
what was
Okay,
he?
Millers,
Therefore, the question is, if he is a person falling under these,
I'm a farmer in the village. And that's why, Millers, I needed someone. And your lordships have
when
seen.
you seek
You're
the
not
help
a
of
rustic
somebody,
villager.
Yes,
You're not a rustic villager, huh?
Millers, I am a rustic villager with great respect.
even then,
No, that's not
understand,
the point, Millers.
understand the
Because
question is,
I needed someone to look after my affairs.
Whom you contacted is a
Yes,
question.
yes, Millers.
And if that person happens to be a person falling squarely satisfies the other conditions D, E, and etc., then
Millets, I will not forget the
You
fact
cannot
that
escape the
he was
liability.
granted the bail. He was granted the bail, and
But
my
for
lords
whom?
are supposed to interfere.
one thing. For whose benefit it is?
Millets, ultimately,
Yes.
then Millets, when it comes to the contact and other things, Millets, it's been come on record, they've got all CD reports and other things, that I have had no contact except on one single occasion for 27 seconds. This is all that I have been accused of. Millets, and my lords have been deciding a question of bail after my 3 years of incarceration and 10 months outside, and not even an incident against me with regard to my abusing that liberty.
You'll consider.
And my lords,
Consider all
99
those-
witnesses. My lords may can appreciate.
We are
You
yet to
lords
take
have had
a,
many
we
a
are
time.
yet to make up our mind.
So be it.
We will go through all those provisions and then
Precisely, Millets. Millets, my last week I appreciate only one last thing, Millets. 99 witnesses, charges have not been framed yet. It's anybody's guess how long it's going to. Millets, if I am pushed back after all these years, Millets, it's in my humble submission, a very inevitable hardship, Millets.
how long you were behind the bars?
Millets,
How long you were behind the bars?
37 months, Millets. And now I
Both
did
one,
it
both
last
one
10
and
months.
two. Both 1 and 2.
Yes, Millets, both 1 and 2. And Millets, litigation has been a decade long. I've been enjoying stay in my favor. I had no immediate motive, even to cross otherwise.
Motive is clear.
Millets, this order has not been referred to.
Motive.
Both 37 months.
99 witnesses, Millets. Charges are to be framed.
But charges started 3 years ago, but still haven't been completed because they keep filing
When
applications.
charge has not been
return of car,
framed,
return
Millets,
of
the question of
this.
trial doesn't arise.
207 was long over, it's not 207.
2 months incarceration.
According to us, it is 26 months, not 37. 26.
Millets, we stand by our statement, it's 37.
It's a little
There
over
cannot
2
be
years.
controversy with regard to statistics, as a matter of fact.
You only said
Millets, borrowed and
according to the petitioners it is 26.
Yes.
According to A1 and A2 it is 37.
Millets, should we file an affidavit to that effect with the record of the jailer?
You will definitely go through that.
My lords have said, Millets, even when there is an observation, it should not influence, it will influence. That's the fear. Grateful, Millets, for the opportunity.
Lordship.
Please, Your Lordship. Your Lordship, may I just mention item 61? Your
Just
Lordship? Please.
Yes.
Please, Your Lordship.
That-
Your
just- yes.
Item 57, I appear for the response.
Bar, of course, when the senior counsel is there, you will have to.
Yes, sir.
Please also.
Please, no.
But you were saying. Sorry. Then
57, my lord,
item.
item 57. Lord, there is an interim order against us.
All interim orders where now we will have to.
Against us, but
Against then we will have grant only a short test.
I'm praying for a date.
What is the nature of the order?